Hello and welcome to our Facebook Live version of our podcast, Absolute Trust Talk. I'm Kirsten Howe. I'm the host of Absolute Trust Talk, and thank you for joining me here today. Today, I'm going to give a little talk. The title of my talk is How to Avoid the Most Common Estate Planning Mistake. And honestly, I should have done this a long time ago because it really is the most common mistake and people need to avoid making this mistake. Years ago, I used to give a presentation that we called 10 Gruesome Estate Planning Mistakes. And by talking about the bad things that you shouldn't do in your estate plan, we were educating people about how to do a good estate plan. And so we would talk about things like how not to leave a bunch of money to an irresponsible child or an immature child or a child with a substance problem, or we talked about all the things that are wrong with adding a child onto the title to your home. So mistakes like that were kind of interesting, and they had good stories behind them, because you want to educate, but you also want to entertain a little bit. But this most common mistake I'm going to talk about today is a more boring mistake. It's not like that. We do, in addition to estate planning, we do trust administration. So that's the legal work that happens when somebody dies. And I would say that it's very rare for us to do a trust administration for a client and not have this mistake show up while we're working with the client. And what I'm talking about is improper funding of the trust. So funding of the trust is transferring assets into your trust so that your trust owns your assets instead of you. And I want to say probably 95 times out of 100, we find an asset that didn't get into the trust and should have gotten into the trust. And now our grantor has died and we have to deal with that problem. One of the main reasons that we use trusts in estate planning in California is to avoid probate. We want to keep the family out of court. We want to make things simple. We want to keep costs down. So we set up a trust to avoid probate. And what happens when you have assets that should have been in the trust, but they're not in the trust after you die, many times we have to do a probate. And right now I have several probates like that where we're administering a trust. The trust was set up to avoid probate, but we have to do a probate anyway. So I want to have this conversation with you today because during this coronavirus time, I'm having lots of conversations with people who are worried and people who haven't done estate planning and they want to get that going. They might have procrastinated for many years and now is the time and it feels more urgent. But I'm also having a lot of conversations with people who already have an estate plan, and the thing that they are focused on and worried about is everything the way it should be? Have I taken care of everything? Do I have the assets in the trust? And I think that that kind of naturally flows from just being generally fearful and anxious and worried because of the coronavirus. It also might be that, some people aren't working as much as they were before, and so they have a little time on their hands. And it also might be maybe this, tying up all the loose ends in their estate plan is an excuse to go off in the corner and get away from their family. They're tired of sheltering in place with. I don't know what it is, but I'm finding myself having a lot of those conversations right now. So I think this is a good time to help you all figure out where you are and come up with a list of things that you need to take care of. So what I'm going to do is talk about various different kinds of assets. And for each kind of asset, I'm going to talk about, number one, should it be in the trust? Number two, how do I get it in the trust? And number three, how do I even know if I already put it in the trust? Maybe you took care of that many years ago. So we're going to talk about those three things for a variety of different kinds of assets that you may own. You may not own all of them, but I'm going to cover kind of the basic ones. All right, so when we are working with a brand new client who wants to do estate planning, we send them a worksheet designed to get kind of general information about them. So I'm going to kind of go through these assets in the order that they show up on our worksheet. And the first asset that we have our clients tell us about is their real estate. So real estate means your home. You might have a vacation home. You might have a rental property. Some people own timeshares that are actually real estate. So anything real estate, should it be a trust asset? That's the first question, and the answer is yes, it should be a trust asset. How do we know if how do we get our real estate into our trust? Well, the way that real estate changes ownership is with a deed. You know, when you bought your home, the person who sold you the home signed a deed and they transferred it over to you. And that's the same thing that you do when you want to get your real estate from you to your trust, is you sign a deed. So you probably, when you first set up your trust, you would have, at the same time, in that same signing appointment, you would have signed a deed to put your real estate into your trust. But sometimes people have recently acquired new real estate. You know, they set up a trust 10 years ago, but now they bought a new home. They moved out of their old home, they bought a new home. That needs to go into your trust. And probably your estate planning attorney doesn't know about it unless you've gone back and you've told them. So how do we get it into the trust? We sign a deed. My recommendation is that you work with your attorney to do that. I don't recommend that clients fill out their own deeds and get them recorded. There's just too much room for error, and an error is very expensive. So you're going to go back to your attorney. How do you know if you did it? Maybe you did it correctly the first time around and you don't need to worry about this. One way is to go on the county recorder's website. In Contra Costa County, you can go on the recorder's website and you can search for the last recorded deed on your property. And if it says trust or trustee or anything like that, the last recorded deed, then your property is owned by a trust. I wouldn't necessarily rely upon seeing that online. My recommendation is that you order a copy of that deed so you can actually read it and see it actually is owned by my trust. Again, your attorney can do that for you very easily. We use title companies. We have software that helps us do that. So my recommendation is go back to your attorney and just verify that your real estate is in your trust or get it taken care of. Okay, so my next category of assets is bank accounts. Everybody has a bank account for the most part, and should your bank account be a trust asset? And the answer is, it depends. You know, that's the old joke. Anytime you ask a lawyer a question, that's what they're going to say. Most of your bank accounts really should be trust assets. Remember, we're trying to avoid probate. So anything that you leave outside of your trust, you're running that risk that you might end up causing a probate. Most of us have more than one bank account. We might have a savings account and a checking account. Our checking account often is just an account that money goes in and money goes out, and it never has a whole lot of money in it. And it's also oftentimes linked to other things. So a lot of us who have a job, our paycheck gets direct deposited right into our checking account. So we can't really make accounts like that trust accounts, because you know your employer isn't going to direct deposit your paycheck into a trust account. They're going to deposit it into an account with your name on it. And you might have things like, you know, maybe your gym membership gets automatically deducted from your checking account every month. So if you change that account, then you have to change all those automatic things, set them up all over again, and that's kind of a pain. So it's okay to leave your checking account, your basic household checking account, outside of your trust. Just remember, we're always trying to make sure that we have less than $166,250 outside of the trust total. That's the number that will cause your family to have to go to a probate. So for me, that's plenty. My checking account never has that much in it. So my checking account is not in my trust. And that's okay. Okay. So how do we know? No, the second question is, how do we get our bank accounts into our trust? We go to the bank. You can't do anything without actually dealing with the bank. It's their account. You have to deal with them. So you just go to your bank and tell them, this is what I've done. I have a trust. Here's the name of my trust. I'm the trustee of my trust. Can you please make this account be a trust account? And they have the paperwork. They know what they're doing. They do it all the time. It's very simple. The third question, how do I know if my bank account is owned by my trust already? Maybe I already took care of that. How you know is you look at your bank statement. Every month you get a statement from that bank and it tells you who is the owner of the account. If it says your name, then it's not a trust account. If it says your name as trustee of your trust, then it's a trust account and you did your work and you're done. That's good. Okay, so the next category of accounts or assets is investment accounts. So a lot of us have, like a Fidelity account or a Vanguard account or Morgan Stanley, something like that, where we own stocks and bonds and things like that. These are very similar to bank accounts from my perspective of transferring assets into the trust. What you need to do is deal with the institution. If it's Fidelity, you either call them up or you go into one of their retail locations and you explain to them, I have this trust, here's the name of it, can you please make my account a trust account? These investment accounts definitely should be trust assets, and that's how you do it. And again, how do I know if I already did it? You look at the statement, and if it says your name, you didn't do it. If it says your name as trustee of your trust, then you did do it. Now, if you have a financial advisor at this institution, say it's Morgan Stanley, and you have a Morgan Stanley person, it's easy. All you do is you call up that person and they'll take care of it for you. That's part of what they do for you as your financial advisor. Okay, next category. Some of us own, I don't, but some of you perhaps own individual stocks. You don't have them in a brokerage account. You just own shares of Apple, whatever, and it's not in a brokerage account. How do we deal with those? And should those be trust assets? Yes, they should be trust assets. How those kinds of things get transferred, the publicly traded securities that we just own, they have usually been sort of delegated to what we call a transfer agent, which is a business that takes care of all their stock transactions for them, so that the corporate headquarters doesn't have to do it. They put that out to a transfer agent. The most common transfer agent you'll see is called Computershare. And so if you own stock that Computershare is the transfer agent for, you get a statement from time to time and it says Computershare on it. And so when you want to transfer those shares, you have to deal with Computershare. So, if you own shares of Coca-Cola and Computershare is the transfer agent, I don't know if they are, I'm making that up, but you're not going to call Coca-Cola headquarters. You call Computershare and say, I have this trust, here's the name of my trust, can you please? So you have to go through their process. They have their documentation and they will tell you what to do, and you just get it done that way. And again, how do you know if your stock is in your trust already? you get that computer share statement and you look at whose name is on that. Is it your name or is it your trust name? And that's how you know. This next one is a little different. Some of you may own a business or a part of a business, not a publicly traded business, but maybe you have your own business or you're in partnership with somebody, and so you own shares in an S corporation, or you have a limited liability company, an LLC. You might own an interest in something like that. Should those be part of your trust? And the answer is yes, they should. How do we get them into your trust? It depends. Really, it depends on the governing documents for that business. So if it's an LLC, it will have an operating agreement, and somewhere in that operating agreement, it says when a member wants to transfer their membership units, this is what they have to do. Sometimes it's just they have to notify the manager of the LLC. Sometimes they have to get the written consent of all the other members of the LLC. It just depends on the governing document for that business entity, what you have to do. So how you do it is you get a hold of those governing documents. As I said, with an LLC, it might be an operating agreement. With a corporation, it might be a shareholder agreement. If it's a partnership, we would call it a partnership agreement. But there's some document somewhere that tells us what is the procedure, and you have to comply with that procedure. So that's all. Those are very individualized. I can't give you a blanket answer for exactly what to do. You just have to read the document. That's always the best place to start. The last two asset categories I'm going to talk about are a little different because we generally are not changing ownership of these assets. We are changing the beneficiary on the assets. So I'm talking about, first of all, life insurance policies. A lot of people own life insurance policies, and we don't need to make your trust the owner of the policy. It's okay if you remain the owner of the policy, but oftentimes what we want is for the trust to be the beneficiary of the policy. So how does that happen? You call up the insurance company and you explain to them, this is what I want. I want my trust to be the beneficiary of my life insurance policy. If it's life insurance that you have through a job, then you can go to the HR department and explain to them what you want. They'll have a form for you to fill out. That's what HR is about, is filling out forms. And they'll take care of it for you. Sometimes with a life insurance policy that you own on your own life, you can call them up and they say, okay, we'll make the change. And then they just send you a confirmation letter. And you don't really have to do anything except for that phone call, as long as they did what you asked them to do. So again, with the life insurance, we don't necessarily want to change the ownership of the policy. We just want to make sure the beneficiary is who we want it to be, and oftentimes that should be our trust. The last category of asset is our retirement assets, and they're very different from all the other assets we've been talking about because they have a tax burden on them. Remember our IRAs and our 401ks, we put money into them and we didn't pay any income tax on that money when we put it in there. We have to pay that tax when we take it out. So for that reason, they are very different from our other assets. We never want to change the owner of our retirement assets. The employee who earned that money is always going to be the owner of that account as long as they're alive. Because if you change the owner, the IRS considers that to be a distribution and they're going to tax it. So we never want to change the owner. We just want to make sure we get the death beneficiary correct. And it's very similar to a life insurance policy. You want to make sure that you've named a beneficiary. you need to talk to your attorney about should it be a trust or shouldn't it be a trust, because there are some complicated tax issues there. Most of the time, we want the beneficiary of our retirement assets to be our spouse, if we have one. And then the secondary beneficiary would be our children or whoever else we want to be the beneficiary. If you don't have a spouse, then those people would become your primary beneficiary. It's important to have a primary and a secondary, because what if your primary beneficiary dies before you do? So very important to take care of that. This is where we get a lot of these probates in my office. People have IRAs that they forgot about. They designated a beneficiary many, many years ago, and that person died, and then they die. And now we have to do a probate for an IRA or for a 401k. I've had to do that, and that's really a terrible result, because that's a lot of money that could easily have been saved. So part of this trust funding process is to also go back and check all those beneficiary designations and make sure you've gotten them right. Okay, I want to say one last thing about all of this, and it is you have to not only get this done, but you have to keep it done. So, you can set up your estate plan, you can get all the assets transferred, and everything's beautiful and perfect. And then 3 years later, you go and open a new bank account, and you don't do that correctly. You don't title it correctly. This is a lifelong project. As long as you're alive, you're going to always keep your trust funded, no matter what the assets are. So you can't set it and forget it. You have to keep it in mind whenever you acquire a new asset. And that way you won't be one of those, your family won't be one of those clients who has to do a trust administration and a probate. I don't want to see that happen for you. All right, I do have some questions, so I'm gonna go over to my questions. First one, can you transfer real estate into your trust if you own the real estate with another person? So the answer is yes. We do that all the time. You might own, sometimes we see clients who own a vacation home with their sibling. And you transfer your interest, your 50% or your 30% or whatever it is, into your trust, and it doesn't affect the other owners. So the answer is yes, you should do that. What should be done with stock options that are issued as employee compensation? So I didn't mention stock options in my categories of assets that we were talking about today. They're a little more complicated. Most of the time, stock options can't be transferred to a trust. They can't be transferred to anybody else, because they're not yet exactly assets. They are a right that you have. Once you exercise the option, in other words, you buy the stock at the option price. Once you exercise your option, then you own the stock. And it's the stock that should go into your trust, yes. But when it's still an option, usually you can't transfer it to a trust. So, and it depends, but usually you can't. Okay, next question. Do you recommend that people transfer rental property in other states to their trust? Okay, so like you live in California and you have your home in California, and you also own a rental property in Las Vegas, which is another state. That's Nevada. So the answer is yes, I do recommend that any real estate that you own anywhere in the United States should be owned by your trust. What happens if you are a California resident and you die and you have real estate in another jurisdiction that's not in your trust? Your family is going to have to do a probate in that other state. So there would be a Nevada probate in the example that I just gave you. And if you do, even if you have to do a probate in California, you still would have to do another probate in Nevada. You would have two probates going on. We call that an ancillary probate. So you definitely don't want to do that. Very important to take care of all the real estate. Okay. My next question looks like it might be my last question. I have a friend who inherited some real estate in India from her parents. Should she have a trust for that? So that's a complicated question. The answer is that your United States trust is not going to own property that's located in another country. I have lots of clients who have foreign real estate because they inherited it or they bought it or whatever. What they need to do is we do their US estate plan, and then we find them a lawyer in that other jurisdiction to help them do an estate plan there. So those people will actually have two estate plans to cover the two different locations where they have property. Okay, now I thank you very much for your time here today, for listening. It's nice to have someone to talk to, even if I can't see you. I'm just going to remind you, today we're talking about funding your trust. This is maybe the most important thing that you can do to make things smooth and easy. After you've set up your estate plan, make sure it's fully funded and keep it funded. And that's my advice for you. Now, we are going to be continuing to do these Facebook Live events, so I hope you'll join us again next week. And I'm going to also remind you that for a little bit longer, we are running our coronavirus estate planning special. We have put together a special package deal for doing a comprehensive estate plan. Most people can make use of it. Some people's situations are just a little too complicated and it won't work for them. But for most people, we can. And we have a special price for single people, $2,500, married couples, $2,950. Give us a call, 925-943-2740. You can visit our website. There's lots of free educational resources on our website. I encourage you to check that out. You can see our newsletter, you can see our blogs, you can see our podcasts, and we have guidebooks that will walk you through the estate planning process. You'll know what you're doing and what to expect. So that's absolutetrustcounsel.com. You can even on our website actually schedule a call with us. We have a little calendaring tool on there, so you don't even have to pick up the phone. You just click and somebody will call you. So check it out. If you have any questions, we're happy to answer them. Give us a call. We're open for business. Our doors are closed. We're working remotely, but we are still working. We're getting it done, and we'd love to help you. Thanks, and stay safe.